Our final speaker for this afternoon's event is our principal lawyer, Hattie Owens. She'll be talking you through our approach to our enforcement powers. We've mentioned this briefly before. Obviously, you heard from Grant around our approach to the complaints part of our powers, and Hattie will now give you the overview of the other elements of that enforcement policy. So over to you, Hattie.
Thank you so much, Mike, and hello to everybody. It's very exciting to be here talking to you all today on this most momentous of days for the OEP. So as part of launching our draft strategy today, we're also launching our draft enforcement policy, which is contained within the strategy as an annex. And the enforcement policy is a really important piece of the OEP jigsaw. As we recognise in the draft policy, and as reflected by my colleagues from whom you've already heard, enforcement is just one of our functions. It's part of a wider toolkit, and we'll use it where it's the most appropriate tool for the job. With that in mind then, we can use our enforcement functions to hold government and other public authorities to account in relation to their compliance with environmental law. As noted on the slide, in this draft version of our policy, we have explained how we intend to do this, and we really look forward to your views on what we've set out. Now, as we've already heard, we've spoken to a number of people as we've been developing these proposals, and I want to take this opportunity to echo what my colleagues have already said, and just to say thank you so much to those of you who have enthusiastically engaged with us so far. These conversations have been really valuable as we've been finessing our thinking, and we're very much looking forward to further engagement with you through our consultation period. I'll now take you through some of the key aspects of the enforcement policy in its draft form. But note that this doesn't cover all of the policy's content, so I'd encourage you to have a good read through before responding. When you take a look, you'll see that we've set out our proposed approach to how we'll use the powers and duties that make up our enforcement functions in order to further our principal objective. We've set out 3 general principles which will underpin all of the enforcement work that we do. The first general principle is that public authorities must comply with the law. Whilst this might sound obvious, we think it's valuable to explicitly recognise this. This means that any failure to comply with environmental law by a public authority is potentially within the scope of our enforcement functions. Our second general principle is that enforcement activity should be targeted to where it's most needed. As Andy's already discussed more generally, we need to prioritise our work. This is also the case in the context of our enforcement functions. We won't be able to pursue every matter that we could potentially take on. As part of our prioritisation, we will consider where we could make the most difference, where we could have the greatest positive impact. This might include in relation to systemic issues or individual but related matters which, when taken together, could give rise to serious damage. Our third general principle is that our enforcement activity should take account of all of the relevant circumstances. Now, the relevant circumstances will vary from case to case, but we'll need to conduct our assessments on the evidence available to us at the time, and we'll need to exercise our professional and impartial judgment in considering that evidence. Moving on from the general principles then, more generally, our aim with our enforcement functions is to identify, address and importantly resolve issues of non-compliance with environmental law. We'll be proportionate in how we do this. For instance, we'll normally try to resolve matters through cooperation and dialogue with public authorities, but where we need to, we'll not be afraid to use our powers to take public authorities to court. Our enforcement policy also covers exactly what our enforcement powers are. We have a range of powers and duties that make up our enforcement functions. This includes a suite of new powers specific to us. As my colleague Grant has already discussed today, we can receive complaints from members of the public about potential failures to comply with environmental law. There's no charge to submit a complaint to us, and we accept complaints submitted in a variety of ways. We can also conduct investigations into potential failures. As part of this, we can request information from public authorities to help us get a comprehensive understanding of the issue. If we conclude an investigation and decide not to take any further steps, we will produce and usually publish an investigation report. This must include our conclusions following the investigation and, if we have them, any recommendations that we'd like to make. Where we're satisfied on the balance of probabilities that a public authority has failed to comply with environmental law, we can give them a decision notice. In this notice, we can set out the steps we think the authority ought to take in relation to the failure, for instance, to remedy the issue or prevent its recurrence. Public authorities are obliged to respond to this, explaining whether or not they will take the steps we've recommended, as well as any additional steps that they intend to take. And finally, where we need to, we can commence proceedings in the High Court through a bespoke new mechanism called environmental review. We can also take more conventional actions. We can launch judicial review proceedings in urgent cases, and we can apply to intervene in other parties' cases where we think that we can be of assistance to the court. Our enforcement policy also describes the decision-making framework that we intend to use to make sure that we're consistent in exercising our enforcement functions. In setting this out, we've explained how we intend to approach the assessment of seriousness. Now, as many of you will be familiar, seriousness is an important threshold for us in being able to take enforcement action. If we want to launch an investigation, if we want to request information from a public authority, if we want to take a public authority to court, we must consider that the potential failure to comply with environmental law is serious. Our proposal is that determination of seriousness will be rooted in a factor-based assessment. To this end, we've set out a number of factors that we think will be relevant in assessing whether or not a failure is serious. These factors include, for instance, whether the conduct raises any points of law of general public importance. Does it have wider implications? Would broader legal clarification be particularly helpful in this area? Also includes factors such as the frequency of the potential failure over time, including any cumulative impacts. And also the behaviour of the public authority in question. Have they acted deliberately, recklessly, or negligently? Have they ignored previous warnings or concerns raised about the issue? In addition, in cases that we think might need urgent action, we need to consider the likelihood that without an urgent judicial review, serious damage to the environment or to people's health would result. Again, we've set out examples of the kinds of factors that we think go to the seriousness of potential damage. These include, for instance, the nature of the harm, taking into account the particular characteristics of the people or the environmental features concerned, the degree of the harm, how severe is it, what's its extent, and wider issues such as any indication of a more widespread or systemic problem of which we should be aware. After considering the factors that are relevant, we'll make an overall appraisal of the seriousness based on our independent, objective and professional judgment. We would not normally expect to have to undertake technical assessments in order to reach this judgment. Of course, there will be circumstances in which we cannot be certain of all of the potential implications of a public authority's conduct. In such cases, we recognise the greater scope for adopting a proactive approach where the stakes are higher. Finally, our enforcement policy covers how we'll be objective and impartial, and how we'll have regard to the need to be transparent and proportionate through our enforcement actions. Please do take a good look through the policy. We're really looking forward to hearing your thoughts on and your responses to the proposals that we've set out. I'll now hand back to Mike.
Thank you ever so much, Hattie. That concludes the sort of presentations we've prepared for this event.